Australia needed to enact anti-terror laws after September 11, but unfortunately the laws that we got often went too far. This was partly a response to the fact that these laws were enacted in such haste. They were enacted very quickly after September 11, the attack in London and elsewhere, and those laws were enacted with regard to community pressure to enact tough laws to do as much as possible to deal with terrorism. Another reason that Australia has problematic anti-terror laws on the books is because we are the only Western nation in the world that does not have a Bill of Rights. We don't have a national statement of human rights that could be useful in assessing whether anti-terror laws achieve the right balance. A Bill of Rights would, for example, remind us of values such as freedom of speech, the liberty of the individual, the right to a fair trial and other rights. And these type of values can be very useful in considering what laws to enact and helping us get the balance right and ensuring we don't forget these fundamental freedoms. However, we do need to be realistic about just how useful a Bill of Rights can be in the midst of a terrorist attack. As the experience of countries such as America show, the values in a Bill of Rights can be very easily forgotten in the fear and grief that follows an act of terrorism. It's thus the case that the yardstick provided by a Bill of Rights may not be effective when the laws are passed, but may be more useful after the event. A Bill of Rights can be used in the years that follows to reassess whether anti-terror laws have been properly enacted. They can remind us of those values and enable judges, politicians and others to ask important questions about whether the laws that have been enacted are the right laws or whether they do need to be changed. Other countries are using their Bills of Rights and other human rights laws to reassess their anti-terror statutes. A good example has been the United Kingdom, where the new Conservative government has actually amended their anti-terror laws to repeal their control order regime. That government did so because they wanted to rebalance their laws. They recognised the need to better protect liberty and also that they had gone too far. That means the United Kingdom does not any longer have a control order regime. They've replaced it with something else. Yet Australia still has a control order regime, which we copied from the United Kingdom, but we've taken no like steps to actually remove that from our statute laws. The result in Australia is that we have anti-terror laws on our books that simply aren't found in other countries. Even the United States has nothing like our extraordinary ASIO power, whereby a non-suspect can be held for up to a week and forced to answer questions. The US nor the UK has also sought to pass something like our sedition laws, which enabled people to be jailed for their speech rather than their actions. All this demonstrates that in Australia we have relatively weak protections for human rights, and that those protections can be easily overcome when it comes to anti-terror laws. In Australia, we rely upon the wisdom and good judgment of our politicians, our elected representatives, to pass the right laws when it comes to anti-terrorism. We rely upon them to take action to protect fundamental human rights. Unfortunately, our experience of anti-terror laws shows that wisdom and good judgment isn't always evident. For many people, Australia's anti-terror laws are a thing of the past. They assume that these laws are off the books now that the hot events of the last decade are over. But in fact, most of these laws are a permanent feature of our statute book. They're still there even if they're not being used. This has proved dangerous because those laws are becoming accepted as normal rather than exceptional. They're the sorts of laws that can be copied by the states, for example, as in the law and order debate, they look for new tough laws on bikies and other groups. In fact, we've seen state premiers argue that bikies are the terrorists within their own communities, and so they have copied the federal control order regime to apply to those groups. It shows more broadly that even if anti-terror laws aren't being used, they can provide a source of precedent for lawmakers and so can have a profound effect on other areas of Australian law. Australia's anti-terror laws have been the subject of a number of independent inquiries, including inquiries established by the federal government. What those inquiries have found is that these laws are often dangerous and need to be fixed. Most recently, two major inquiries, one by the Council of Australian Governments and the other by the independent reviewer of Australia's anti-terror laws, have found that in key respects these laws are disproportionate, unhelpful and in fact in some cases dangerous. That's because the laws go too far in the powers that they confer and often may in fact lead to a situation where new dangerous precedents are created for Australian law. These inquiries have, for example, recommended the repeal of preventative detention orders and even the removal of control orders, as well as the significant tightening of a range of offences around Australia's anti-terror laws. What's clear is that we now have a system of law that does need to be changed. Unfortunately, as yet, we're not seeing action within our federal parliament to bring that change about.